If you were falsely accused of domestic violence and arrested, then this video is for you because I am going to be talking about a hack to expose the accuser's lies. My name is Veronica. I'm a domestic violence defense attorney here in California, and I help people with their cases behind them so that they can enjoy their lives and their freedom. I am also the creator of a course called Defeat the DVRO, in which if you have been served, in addition to getting arrested, with a domestic violence restraining order, I teach you in that course from start to finish everything you need to know to represent yourself at your restraining order hearing and win. If that's something you're interested in, you can get your free first class via the link down below. Okay, so let's jump right in. A hack to expose your accuser's lies if they have falsely accused you. Here's how a domestic violence criminal case goes. And this is assuming that charges have been filed against you. Many times a good attorney can get charges dropped before the first court date. But let's say that you go to the first court date and either you didn't get an attorney, they weren't very good, or there was something about your case that made the prosecution really want to file it. And so it does get filed. At that very first court date, your attorney will get a copy of the police report. Now, if the police arrested you, whatever is in the police report is not going to be good for you, right? And the problem is that the police report can leave out a lot of details that could be helpful to show that the alleged victim is lying. Now, the number one way to discredit someone is to show that they changed their story. Now, I'm not talking about small, insignificant details, but details that if they were telling the truth, they surely would remember. So here is what you need to do. Here is the hack. Here's the tip. Get a copy of the body-worn video of the alleged victim's statements. And you're watching YouTube, right? So I'm sure you've seen body-worn videos before. You may not have known exactly what it was, but it's, the police have on their chest a small camera that records everything that they see, including interviews, and it records audio as well. And so that is not something that your attorney automatically gets at the first court date. Sometimes we have to beg for it, insist on it. Sometimes it takes some time just because of how it's all set up on the prosecution's end. But that video is going to be really important because it is going to contain what the alleged victim actually told the police officers on the night that you were arrested. Not whatever's in the police report, which could be a summary, could leave a lot of things out. Maybe multiple officers talked to the alleged victim, but only one of them wrote down what she said. So that is super, super important. Now, just to be clear, you as the defendant are not going to get a copy of the body-worn video on your own, almost certainly, even if you were representing yourself. Your attorney has to get a copy. Sometimes there will be a protective order put in place where you cannot personally get a copy of that video. If that happens, there's an easy solution for it. Your attorney just needs to make a transcript of the body-worn video and give you the transcript. Because the most important thing, again, is what they said. And so I need a transcript to see it in black and white and compare it to anything else. Now, once you have that transcript, you want to go through statement by statement and see if there's anything that is inconsistent. Sometimes when someone is telling a story, even while they're telling the story, you'll notice that there are inconsistencies, right? So see if there's anything like that, and also see if there's anything that you can disprove with other evidence. Okay, so let's talk about the other evidence that might help you find inconsistencies. One piece of evidence that might help is a 911 call. If the alleged victim called 911, they probably gave some sort of statement about what had already happened or what was happening during the call. That's another thing that your attorney has to kind of insist on and request, but can get a transcript of. See if that's any different. If there are differences between the 911 call and the police interview, that is incredibly powerful because probably not that much time passed. They can't say that they forgot something. It just happened, right? It was maybe 15 minutes or so between the time that they called the police and the time that the police showed up. And what else? How about injuries? Injuries that the accuser says were caused by you. Do those injuries line up? Could those injuries have been caused in the way that they say that you committed this act of domestic violence, right? I've had so many cases where somebody is showing an old bruise. It's obviously old. It is faded. It's going away. It's not something where if something had just happened 30 minutes before, it's not the kind of bruise that you would expect to occur. So look very carefully at that and look to see if there are any inconsistencies. What about if you, the person who was arrested, had injuries, but the alleged victim's statement doesn't account for them? If you had an obviously new injury, You had a cut that was bleeding, for example. You had a bruise that appeared very fresh. You had red marks. And either the police took a photograph of that, or you, as soon as you bonded out, you took photographs, which is what you should do. You shouldn't just rely on the police to take those photos, to make sure that they're good, to make sure that they get into the prosecution's hands and your attorney's hands later. If the alleged victim's statements do not account for those injuries to you, then obviously they are leaving something out. And that is something that really needs to be highlighted. What else? Sometimes your accuser will talk to more than one police officer and will change their story. Maybe only one of those police officers wrote the report. If you look at the body-worn video with that police officer and the report that they wrote, maybe it lines up. But then you get the body-worn video of the other police officer. And while the alleged victim was speaking to that police officer, maybe they asked harder questions. Maybe they talked to one police officer and they thought, you know what, I'll make my story a little bit better. And then they talked to the one who wrote the report. All of that is going to be really important to show that they changed their story and they are lying. What about if they filed paperwork in restraining order court? If they filed a DVRO against you? I handle restraining orders and I handle domestic violence cases. So there is a ton of overlap there. If they file paperwork in restraining order court, requesting a restraining order, they are generally writing down their statement about what they claim happened. At that point, they do not have a copy of the police report. It's usually very soon after. They don't have a copy. They definitely don't have a copy of the body-worn video and a transcript of what they said. When you're lying, you tend to forget what you previously said. You didn't live it. You're trying to remember what you said, not something that happened. And so you can forget things, and then you will end up changing your story. Or maybe you embellish it. You think, you know what? I told the cops one thing that worked, but I could have made it even better. And you start embellishing. You add more things for your restraining order. That is gold. That is something that you need to use, your attorney needs to use, the domestic violence restraining order, what they said there, to show that they are lying. They changed their story. Maybe they even testified in court for a domestic violence restraining order case. Now, in that case, you can get a copy of the transcript from court, usually. Some courts now have stopped having court reporters, but usually you can get a transcript of that and use that too. So now, how many times have they told the same story, right? We have them talking to one police officer, maybe a second police officer. We have them filing a request for a domestic violence restraining order that they had to write out. Then we have them going to court and telling their story there. But even if you did not win your domestic violence restraining order hearing, and again, please, if you're in that situation, you cannot afford an attorney, take the class that I have, take the course, and learn how to represent yourself. If the other side is lying, you have a good chance at winning, but only if you know what you're doing. So this applies, though, even if you lost, because just because you lost your restraining order case doesn't mean you lose your criminal case. We are looking for inconsistencies here that can be used against the other side and used in your favor in the criminal case to get rid of the criminal case. And finally, maybe you have evidence that shows that things that the alleged victim has said, are false. You probably did not hear what the alleged victim said to the police officers. Maybe the alleged victim said that they broke up with you and you became enraged and started abusing them. But actually what happened maybe was that you broke up with the alleged victim. And maybe you have text showing that, or maybe you have text saying, we need to have a serious talk. Can you come over tomorrow and we'll have that talk? It may not be 100%, but you may have evidence that shows that what they are saying is unlikely to be the case. If they're saying that the reason you became enraged is because they broke up with you, but you can show that that's actually not true, it calls their entire statement into question. And look, in these domestic violence cases, usually there's not going to be hard evidence. I used to represent people in murder cases and robbery cases, serious crimes, and sometimes if you rob a 7-Eleven, for example, there's going to be HD video showing exactly what happened. Probably not a good place to rob, by the way. But in these domestic violence restraining order cases, it's domestic, right? It's inside your home. It's in privacy. So usually there's not 100% evidence either way, which if you're innocent and you're falsely accused, sucks. And so instead, what it's all about is the credibility of the accuser, not even necessarily you, because as the defendant in a criminal case, you may or may not end up actually testifying, but it's about the accuser. And look, you can be convicted and someone can get a restraining order just based on the word of somebody else with no hard evidence, with no HD video, with none of that. However, that is only if the alleged victim can be believed. If you can show that there are problems with their credibility because they have changed their story or a big part of their story is false, that is a way that you win these cases. I hope you found this video helpful. And if you did find the video helpful, please don't forget to like, subscribe, and ring the bell, and follow me on TikTok, Instagram, and Facebook.